We will hear argument first this morning in Case 24-297, Mahmoud versus Taylor.
Does it burden a family's religion to have their child exposed to views with which they disagree? Where's the line between exposure and coercion, and who gets to draw it? Should public schools be a place where students encounter and acknowledge a variety of viewpoints, even if they don't agree with them? Or should parents have the power to opt their kids out of anything that might conflict with their religious views? Can a diverse, inclusive curriculum coexist with ever-increasing parental rights? Is opting out going to become a constitutional right? I think I'm out of questions. Jamie, that all seems pretty simple, huh? Yeah, right?
Oh boy, we got a lot to do today.
We got a lot to cover. Yeah, because today we're covering something that you, Jamie, personally experienced, the oral arguments in Mahmoud versus Taylor.
I did. Yeah, man. That was a remarkable experience to be sitting in the courtroom, witnessing this kind of questioning and debate about such a complicated and fundamental sort of set of issues, right? Knowing that these are the kinds of cases that really shape education. That was a really powerful experience to be in the room when all of that questioning and wrestling with this kind of stuff was taking place.
Yeah. In the words of Hamilton, you were in the room where it happened.
I guess I was. So we're dealing with some big and complicated issues these days, and this case is one of them. Since we're right in the middle of a number of big education cases at the Supreme Court, we've decided to take some deep dives into these cases over the next few months. And today, we're going to break down the oral arguments in the Mahmoud versus Taylor case that was argued a few weeks ago. By now, you've probably heard of this one. We've covered the circuit court's opinion in episode 12, and there's been a number of news articles over the last month or so about this case. And to help us make sense of all of it, we're welcoming back to the show somebody who's intimately familiar with arguing First Amendment issues in education at the Supreme Court. So in just a moment, we will dive right into this. Welcome to Chalk and Gavel, everybody, where we explore how the law shapes education one case at a time. I'm Jamie Cudlitz. I'm a former middle school math teacher and principal.
And I'm Chris Thomas. I've been a high school English teacher and a school attorney. Now, Jamie and I are both professors of educational leadership, bringing you the fascinating stories connecting the courtroom to the classroom. Literally this time.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
So as Jamie said, there's a lot going on in education right now, from Supreme Court cases wrestling with these fundamental rights to a whole bunch of executive orders and lawsuits challenging those executive orders and all of the stuff that's going on in education law and policy. And Chalk and Gavel is the show that covers, I won't say all of it, but some of it. It'd be hard to cover all of it.
I know, it's a lot.
Yeah.
We have day jobs. Yeah.
As much as I would like to make this my full-time gig.
I know.
Which leads us to our Patreon. Help us spread the word, support the show, tell a friend, like, rate, review, subscribe, all of that fun stuff. You can go to our Patreon page. You can find the link on chalkandgavel.com. Your support means the absolute world to us as we continue to grow this show and keep translating those education legal developments into what it means for the classroom. So with that, on to the show.
Yeah. So again, today we're going to break down the oral arguments from the Mahmoud versus Taylor Supreme Court case. In this case, parents are asking the court to recognize a First Amendment free exercise right to opt their children out of any aspect of the school curriculum that might conflict with their religious beliefs.
Right. And on the other hand, you've got the school board who believes that exposing students to various viewpoints is not coercive and does not burden the family's free exercise rights. Furthermore, the school is arguing that allowing broad opt-outs could open up a floodgate of practical and administrative concerns for schools.
Yeah, so there's a lot to unpack here and potentially a lot at stake. All right. So to help us, we've brought back our good friend, Richard Katskee. Welcome back to the show, Richard.
Well, thanks, Jamie and Chris. Love to be here. You know I'm a big fan.
Thank you. Yeah. So Richard,
we're glad to have an expert here.
Yeah.
This is complicated.
to keep us in check, right? So Richard is an assistant clinical professor of law and the director of the Appellate Litigation Clinic at Duke University. He was part of the Supreme Court and appellate practice at a law firm in D.C., and he also worked as a legal advisor in the Department of Education's Office for Civil Rights. Richard developed policy initiatives on the implementation of federal laws barring discrimination on the basis of race, sex, including sexual orientation, gender identity. He also argued for the Bremerton School District in the famous Supreme Court case, Kennedy versus Bremerton, back in...
The case started back in 2015, actually.
And then it was a 2022 decision. And yeah,
I think it was.
Yeah, so Richard argued for the Bremerton School District in that case. We covered all of that back in episodes 10 and 11. So if you want to hear more from Richard about how that case played out, check out those episodes. But today, Richard is back with us to help us unpack what happened recently in the Supreme Court with this Mahmoud case. We are recording this episode exactly one day after the arguments took place, even though this is coming out a couple of weeks after the arguments. I was going to say,
when you said it was a couple of weeks ago, I was like, wait a second.
No.
Where was I?
Yeah. The day we're recording it.
Right. This might be the quickest we've ever tried to cover something.
Yeah. So
less than 2 weeks. Not bad.
Yeah. So anyway, everything is pretty fresh in our heads right now. So let's jump into it.
Yeah. So Richard, just kind of want to start by getting some context for oral argument at the Supreme Court. I know you've obviously argued in front of the court. We talked about that with the Kennedy case, and now in your role, you teach appellate advocacy, right? So I just kind of wanted to get your take on like, what is the purpose of oral argument like before the Supreme Court? How does it all work, and how does it fit in with how the justices decide these cases?
So look, the purpose of oral argument, when it's done correctly, is always to be a resource to the court, trying to figure out, it's not like giving a speech. You don't try to figure out, here are the points that I'm going to make, and by gosh, I'm going to work my way through them. It's taking questions and responding to the concerns of the justices.
Yeah, that's actually one of the things that I really like that struck me when I was there is how short each side's statement was. Like they just laid it out in probably 1 minute, roughly, and then just went straight into the questioning.
Yeah, the court gives you up to a couple of minutes if you want it. That is actually a new thing. The court didn't used to do that either, and people would get a half a sentence out of their mouths and they would start asking questions because it's about what they want to know.
Yeah.
Not about what you want to tell them.
Yeah. Right. Because at that point, you've already submitted your briefs. And so like they know how you're framing the cases.
Yeah.
That's right. And it's also the case that oral argument is in the most important ways, a conversation among the justices, where as the advocate standing there, you're a foil for them to have their arguments with each other. And sometimes you feel like, I don't even need to be here. They're just doing their thing.
Right. Yeah. You get a lot of those questions of like, here, let me set you up. So how does this violate strict scrutiny? I think it violates strict scrutiny like this. Would you agree? Yes. Okay, well, let me make my next point. And it's like, oh, well, what am I doing here? That's funny. Though you mentioned that the justices kind of have their arguments with each other through counsel. So like the justices, the decorum here is just like justices talk to the attorneys arguing the case. They don't talk to each other, right? Like
usually, yes.
Yeah. Okay.
Occasionally they do, but usually it's they're nominally talking to you, but really talking to each other. Yeah.
Okay.
Yeah. And yeah, we'll talk about one of those moments that
there's an example of that in this case that I think is really telling.
Yeah.
Nice. Okay. Yeah. I love that idea of like the advocate is there to help the justices kind of make sense of, or maybe not make sense of, but like to have that dialogue as they grapple with these challenges. Because that definitely comes through here in this argument, I think we hear some of the justices get a little frustrated with
fiery,
a lack of perhaps concrete guidance, let's say. So before we kind of move on, though, into the actual oral argument, Jamie, like you were there, right? Like you witnessed all of this. I mean, I just kind of want to hear about your experience. And like, Richard, I know you've done this from Jamie was actually press because apparently Chalk and Gavel qualifies as press in front of the Supreme Court, which is the highest like official recognition I think Chalk and Gavel will ever get. But
we've peaked,
right? The Supreme Court thinks we're press.
This is us. Yeah. When the Supreme Court announced in January that it was going to be taking on these cases, this was one of the first big Supreme Court cases that we knew was going to be a big Supreme Court education case in a little while. We had Kennedy, we had Andrew F., in the last, we had the Brandy Levy case a few years ago. But I would say in the last 10 years, that's what we've had at the Supreme Court for the most part in terms of education cases. And all of a sudden we've got some of these we've got this ADA case, we've got the Mahmoud case, and we've got the Oklahoma versus Drummond case.
Next week.
Which is, the arguments are taking place next week. Or last week if you're listening to this episode. Yeah. But when that came out in January, I was like, you know what? I wonder if I could try to get in. And so reached out to another good friend of the show, Mark Walsh, who, education, Ed Week reporter, covers the Supreme Court. And I just reached out and said, what do you think the chances are of me being able to get into something like this? And he basically said, listen, like they open this thing up to the public, if you just want to stand in line, but these high profile cases could, you could come all the way to DC and not get in, right? And I'm not doing that. But he said, with Chalk and Gavel, you should be press now. So why don't you reach out to the Public Information Office? So anyway, Mark helped facilitate a connection between me and the Public Information Office at the Supreme Court. I pled my case via email to them and got an incredibly gracious response very quickly saying, absolutely, we will get you a day pass for this. And they did. And
that day pass said press, Chalk and Gavel. So like, you know.
Right. So they knew.
You got to hang on to that.
I know. I got to frame it, put it up behind the studio here. But anyway, I went down there yesterday morning and there were protests going on outside, lots of, big loudspeakers and people making speeches and music and all kinds of, their LGBTQ rights, people out there protesting or advocating outside the court. And I went in and I hung out in the press office with Mark for a while, and he introduced me to a number of other reporters from other outlets. We went up there, they took us up to the press part, which is sort of off to the left side of the of where the justices sit. And I was probably sitting about maybe 20 feet away from Justice Barrett, who was on one side, on the left side there. Okay. And I could see everything.
Right, because the more senior you are, the closer to the middle you are.
Yeah, there are some press, sometimes when there's a lot of press there, they sit out in the vestibule and you actually don't see anything. Like you just see these pillars and stuff. Anyway,
they're very nice pillars though.
They are. Honestly, and that was one of the things that was so amazing to me about being in this room where all of these incredibly consequential arguments had been made over so many years. And it's just it's a majestic place, right? And with the marble and the carvings and there's just a sense of awe, at least I had, sitting in there, witnessing this. And it really was a fascinating experience. I will remember this for the rest of my life. It's powerful. It really is powerful.
It is. It's funny. The courtroom is majestic, but it is also, when you're arguing, intimate. You're really close to the justices.
Yeah.
They moved counsel back from where we used to be before COVID.
If you were any closer, you'd be sitting on their laps. That was close.
So it used to be you could practically reach out and touch. I swear that one time during an argument, as I was sitting at counsel table and taking notes, Justice Breyer could lean over and see what I was writing.
Wow.
So that was how close we were.
You're right. It's not a huge room.
No.
And it's a relatively small room if you've been there and you're sort of taken the tour or whatever. Like, it's not a huge room. And you're arguing mere feet away from these justices.
That's right.
And that, I don't know, Richard, like it's got to be intimidating.
Well, one thing is once you get going, it becomes a conversation. So when you first get up there, you feel the weight of that. But once it starts becoming this back and forth, then the whole world melts away because all you can see is them and all you can think about is them.
Yeah.
And so you kind of, no disrespect to the incredible Supreme Court press corps, but you don't even remember that they're there.
No. I mean, it's just, it really is it was a fascinating thing to witness. And I hope I get to do it again because, and this time, Chris, we're going to drag you.
Yeah, no, I'm jealous because I've gone to an opinion day. So I was there when they read opinions one time. But seeing an argument, especially one that has consequential implications for education, right? And First Amendment law, that would be awesome.
Well, you want to get into it?
That feels like a good segue.
Let's talk about
the argument.
Yeah. So basically what we've got here is we've got the petitioner, okay, who in this case, they're the parents. It's the Mahmoud side of the equation, right? And then we've got the respondent, and that is the school board.
We also have the government arguing on behalf of the parents.
Right. Yeah. So basically we've got kind of three people who stand up over the course of what turned out to be about 2.5, almost 3 hours.
Scheduled for an hour.
Yeah, this was a long one.
Yeah, it's going to be less. Our episode is going to be shorter than the actual oral argument. We promise.
Yes, it will. So basically, what happens is each of the people who are going to argue something will stand up, give a little bit of the opening remarks, and then it just goes straight into the questioning. And so on the parent side, we have two people, Mr. Baxter. And then we've got Ms. Harris from the government also arguing. And then we've got Mr. Schoenfeld for the respondents. All right. And we're going to play a lot of the stuff for you to actually hear some of these oral arguments.
Right. Because the audio and the transcripts are all available online.
Right.
For those who are curious.
Right. And they're
nerds
available
like us
very quickly after the case drops because, again, we're recording this one day after the case and we already have access to all the transcripts and the recordings. So what do you think, Chris? Do you want to start out with Mr. Baxter's opening remarks and then we can start talking about what he was arguing there?
Yeah, let's start at the beginning.
Mr. Chief Justice, and may it please the court, parents everywhere care about how their young children are taught sexuality and gender identity. That's why nearly every public school in the country that provides sexuality education requires parental consent first. But Montgomery County is an extreme outlier, insisting that every elementary school student must be instructed that, among other controversial matters, doctors guessed at their sex when they were born, and that anyone who disagrees is hurtful and unfair. Forcing petitioners to submit their children to such instruction violates their religious beliefs and directly interferes with their ability to direct the religious upbringing of their children. The board claims this straightforward burden analysis will invite chaos, but schools nationwide have long applied expansive opt-out policies without significant difficulty, including the board itself, which still allows opt-outs for choir students who object to singing religious songs or students who object to certain storybooks, such as one that portrays an image of the Prophet Muhammad. Exempting students for some religious reasons but not others cannot be squared with the First Amendment. Nowhere else to go, the board pleads for remand on strict scrutiny, but petitioners have been seeking preliminary relief for 2 years already at significant personal expense. One family moved in with grandparents to afford private school. Another is homeschooling at the loss of $25,000 a year in special services the school provided their daughter with Down syndrome. Most have no alternatives. Petitioners deserve complete preliminary relief. In a system where thousands of students are daily opted in and out of the class for multiple reasons, there's no basis for denying opt-outs for religious reasons. The board does not dispute that under its theory, it could compel instruction using pornography, and parents would have no rights. The First Amendment demands more. Parents, not school boards, should have the final say on such religious matters.
Yeah, there's a lot to unpack there.
Yeah, right. That was like that last line about like, you know, the parade of awfuls, right? Like, here's the slippery slope. If you side for the school,
then everybody's going to be watching porn. Yeah.
Right. Yeah. Like that, like hyperbole seems so unnecessary.
Well, I got the impression that there were a number of statements made. I felt there were a number of statements made by Mr. Baxter that were really leading people to misleading kinds of statements, right? Like opt-outs exist all over the place for everything. Well, they don't, right? Like, this is a slippery slope, so everybody's going to be watching porn. It felt a little sensational at times.
Right.
I think that's right. You know, one of the things that I teach my students in advocacy is that your credibility matters immensely. And so you don't overstate. You be very careful. You make your arguments, but you be very careful to be representing things as correctly as you can. Now, you know, sometimes advocates make a calculus. A majority of the justices are on my side, and I can say what I want, and I can use the hyperbole, and I can overstate things, but we like to think that that doesn't work. Here, I agree with you. I think that there was a lot of that, including in the part that you just played, the stuff about how there are opt-outs all over the place, all across the country. What he was doing was, I think, was conflating, and I think intentionally conflating, sex education, which is a unit in health class for which there are opt-out rights that school districts create or states create. They're not constitutional, but they afford these things, versus making kids aware that there are people in the world who are gay or trans, and treating those as though they're exactly the same thing, and that it's like looking at pornography or talking about how they're talking about concrete, graphic sexual contact in classrooms, when that's not what this is about at all.
No, and we already have rulings that have talked about, you know, things that are, Fraser, you know, things that are rude or lewd and vulgar and all kinds of stuff and developmentally age appropriate, you know, material. You know, you can have a book in the high school library, for example, that you wouldn't have in an elementary school library. As a side note, one of the interesting things here is that there was so much of these arguments that were focused primarily on religion, but they did bring up age, you know, a number of times. So it's going to be very interesting to see what the court opinion is on this and whether or not age does factor into this at all. But I think a lot of the stuff was sensationalized, was sort of overblown at times. And I think, to your point, Richard, like, you know, maybe there was a calculus here that, you know, I've got the majority on my side, so I'm going to see how far I can take this. And, you know, I think the end result, you know, seems like
maybe I think there's some reasons to think that this is going to be a pretty narrow decision.
It could be.
But yeah, I think that like that first line in the way he's framing the case, right, is like instruction about human sexuality. Right. And Richard, to your point, like this isn't instruction about human sexuality. This is exposure to different ways of being, or different identities. Right. Well, potentially, depending on who you believe. Right.
Yeah, exactly.
So, yeah.
And I will say, just real quick, if you want more information about exactly what is going on here, go ahead and listen to episode 12, because we dig into what this case is all about. We talk about the books in question and things like that. But the short version is, these were books that were adopted to be a part of the English language arts curriculum to allow the teacher to teach things that are a part of standards that are a part of the English language arts curriculum about identifying themes and stories and character analysis and things like that. And in these books, they happen to represent, or they happen to be books that have characters who are LGBTQ.
Right, and that wasn't an accident, right? Because the school board did a curricular audit identified that it was heteronormative and that it didn't adequately represent diverse people.
Right.
And so they added stories of those diverse people into the curriculum.
Right.
And so it went through the curriculum process, which, has a lot of steps and like committees.
A lot, yeah.
A lot.
We love committees in education.
There's parent involvement in many of those steps.
Yep.
So,
But the issue is that they initially allowed an opt-out for families that didn't want their kids to be exposed to these books, but then they took that opt-out away.
Yeah.
Rather abruptly, which also plays into a lot of what is happening here.
Yeah.
But Jamie, you raise what I think is like, to me, one of the key points of dialogue or arguments that the court is having, which is like, what do these books teach?
Yeah.
And I think that is like so important because so much of it is about not just the books, but also the teaching resources as well. And so I think that's like maybe the second question Justice Alito kind of asks, like, what messages are these books teaching?
Yeah.
And I think that goes to the heart of this case because there's a couple ways that the justices were talking about it. Some of the justices were saying like, no, these books just show different ways of life. And they just acknowledge the fact that there are LGBTQ people in the world and that some of them get married. Whereas you've got other justices who are saying like, these aren't just kind of showing you these ways of life, they're actually promoting ideologies related to kind of the moral value of beliefs. And so like Justice Alito really kind of hits on this. And he says like, whether or not these are good values or not, like these books have inherent moral messages. And that seems to be, for Alito at least, a problem.
Well, I mean, look, it's hard to find anything that could be in the curriculum that doesn't have some message, right? But the answer that the school district's lawyer gave to those sorts of questions was, look, these are about teaching language arts. They're also about, as you said, recognizing that we have a diverse community that we represent. And he talked about teaching civility. You don't have to believe, you don't have to like, but we still treat each other with respect. And he explained that as one of the aims here.
Yeah, and I think there is potentially a big disconnect here between what some folks feel is exposure and what some people would classify as coercion or sort of being forced to accept and express your acceptance of something. And there's a lot of talk about the support materials, for example, that went along with these books that were provided to teachers and that gave teachers some language to use when kids say, wait a second, I didn't know that two boys could get married or something like that. Or, boys can't wear dresses, and it gave teachers some language to sort of engage in that kind of dialogue at an age-appropriate level. And there's some people that are arguing that, either that's not age appropriate or they're arguing that the messages either in the book or in the support materials are not mere exposure to an idea.
Right. They're expressing value.
They're expressing that this idea is the right idea. And if you don't agree with it, you're wrong or you're a bad person. And there was a lot of dialogue yesterday around those kinds of issues.
Particularly with like Justice Alito and I think Justice Barrett, really exploring those ideas. And then some of the liberal justices kind of, going more towards the like, this is just exposure. Cause like there's a really telling exchange, I think, between Justice Alito and Justice Sotomayor. Where they're like arguing about the meaning of a kid's book.
Yes.
And like, I know that like sounds so silly, right? Like these are Supreme Court justices arguing about how to interpret a child's book, but it has profound implications, right? So Jamie, I think we've got that clip, right?
Yeah, you want to play the clip?
Before we move away from the book that Justice Sotomayor was referring to, Uncle Bobby's Wedding, I've read that book as well as a lot of these other books. Do you think it's fair to say that all that is done in Uncle Bobby's Wedding is to expose children to the fact that there are men who marry other men?
No, Your Honor, and this court in Obergefell promised that parents would be able to continue to teach what this court called decent and honorable beliefs, that same-sex marriage is immoral according to their beliefs. And it's a far stretch from that for schools to compel students to attend. Parents are paying taxes. They have to pay at threat of criminal fines or penalties or the expense of private school. And then to have teachers telling them things that are directly contrary to their beliefs.
The book has a clear message. And a lot of people think it's a good message, and maybe it is a good message, but it's a message that a lot of people who hold on to traditional religious beliefs don't agree with. I don't think anybody can read that and say, well, this is just telling children that there are occasions when men marry other men. Uncle Bobby gets married to his boyfriend Jamie, and everybody's happy, and everything is, it portrays this, everyone accepts this, except for the little girl, Chloe, who has reservations about it. But her mother corrects her. No, you shouldn't have any reservations about this. As I said, it has a clear moral message.
Wait a minute, the reservation is about...
Can I finish, please? It has a clear moral message, and it may be a good message. It's just a message that a lot of religious people disagree with.
Right. Yeah. So, and the fact that Justice Sotomayor kind of interrupts Alito there, number one, I've also read Uncle Bobby's Wedding, and as an English major and a former English teacher, I question Justice Alito's literary interpretation skills.
So
that is neither here nor there.
Right.
Well, I guess it is here or there because that's kind of his job.
It is. But what was Sotomayor's? What was her point?
Her point is the child there that's expressing reservation is expressing reservation because her favorite uncle is now splitting his time, not because her favorite uncle is gay.
Exactly.
Right. And so. And that's the thing, with a lot of this stuff, if you swap the sex of the partner, is it the same story?
It could be exactly the same. Yes.
It's exactly the same story. So to me, that doesn't have a moral message about the rightness or goodness of same-sex marriage.
But Alito was trying.
Those books don't promote opposite sex marriage.
But it sounded like he was trying to infuse that book with a meaning that was clearly not.
Well, and that's the line, right? Between does this stuff teach human sexuality? And, that has serious implications legally because there's opt-outs for religion in human sexuality for the health curriculum. And, Richard, we're going to talk about it here in a second with general applicability.
But if the answer to that question, Chris, is yes, then any book that has any relationship whatsoever in it is doing the exact same thing.
Which applies to straight and
that's what I mean.
cisgender people to the same way it applies to LGBTQ
That's what I mean.
people.
If there is a relationship depicted in the book, then technically it's a book that depicts sex and sexuality.
And Justice Alito's, imposing that view on the text speaks to another problem too that came up in various ways in the argument, which is who's going to make these determinations? Is it going to be school boards with parents, involved and that whole process that I think, Chris, you talked about earlier, or is it going to be judges sitting back in their chambers and looking through and deciding we're going to act like the experts in an elementary school curriculum and figure out what these things mean? And that's something that in other contexts, the justices and the courts in general have been incredibly hesitant to do. And yet here, there are a whole lot of them who seem quite happy to take over that role from schools. At the same time that we have all the talk about the importance of local control of schooling, which we've always had, but that debate is really hot right now too. This kind of goes directly against that.
Right, and Justice Jackson makes those exact arguments later with the school district, saying we don't want to erode local control. We have democratically controlled schools for a reason, and within that, there are once you decide to send your kids to public schools, you kind of have to accept the results of the democratic process. Yeah, there was a lot of debate about whether or not sending your kid to a public school is what was the language they used? It was a benefit
versus
a mandate or something like that.
That's right.
And that is honestly something I did not understand. So Richard, please help me. Well, because what we're trying to decide here is like, which standard do we apply? And so there's a couple different standards here that are kind of at play. And like, Justice Thomas asked everybody about Yoder versus Wisconsin. And then Justice Barrett is asking everybody, like, is this a public benefit case or is this a Smith case? And like, I know that those laws and I know the general frameworks, but like, I guess what's the significance of which bucket we put this case in?
Well, so what they're doing is essentially arguing, as you said, about which legal standards should apply. And there's one line of cases that says if there is a public benefit, the government is providing something, it can't condition the receipt of that benefit on your religion. It can't say that only Protestants but not Catholics and Jews can get Social Security. And it also can't say you have to give up the practice of your religion and practice my religion instead in order to get that benefit. So what the petitioners, the parents, and the government argued was that was what this case was about, is saying that if you want the benefit of public schooling, you have to give up on your religious beliefs. Now, I think that's a misdescription, but that's the argument that they're making. Justice Barrett and Justice Gorsuch also picked up on this, had a different view, or were exploring a different view, let's say, which was that instead of being about a public benefit, the public schools, there's a mandate, you have to go to the public schools, and therefore we're coercing people to take on this instruction, and therefore that is religious discrimination. There are several steps along the way there that I found to be puzzles. One of them was what Justice Jackson was going through, which is you can go to a private school and you have an absolute right to do that. You have a right to homeschool. And the other,
Pierce versus Society of Sisters.
Exactly. And so is that what we mean by coercion, as opposed to you've made a decision to go to the public schools and you kind of have to take the package that it is within reason, and within reason means the schools try to leave space for religious accommodations, and there are a few things that are required in that, and there are a few things that are required by the Equal Protection Clause and by the Establishment Clause that you can't teach. But otherwise, schools decide, they make the decisions, and just like anything else in the government, if you have objections to that, that's the cost of deciding things democratically.
Okay. So there was a lot of conversation around this idea of burden.
Yes.
Which bucket does that fall into?
Well, so that was a debate also. It definitely, if we're under Wisconsin against Yoder, which is about the case about the Amish not wanting to send their kids to school past the age of, was it 16?
I think it was 16. They said 18 in the arguments, but it was 16.
Incorrect.
Yeah.
I think it was 14. It was just after middle school.
8th grade or something.
Yeah.
Okay. Yeah, I guess that would be 14. Yeah, that's right. 14 versus 16. I don't know where 18 came from in the argument, but that's right. So Wisconsin against Yoder, the idea is that you might end up with strict scrutiny, the highest level of analysis, if you're burdening religion, if you're creating a substantial burden on religious exercise, which is you're interfering with my ability to practice my faith in a really substantial way, which has historically meant you're compelling me to do something that is contrary to my religious beliefs. In Wisconsin against Yoder, it was you're compelling me to send my kid to a public school when it's a tenet of my faith that children from age 14 on are supposed to be in the home and the family and working in the community instead. And so that's one line. And the other line is, when you're talking about a public benefit, it's supposed to be this sort of more limited thing of, are you compelling me to change my religious practice in order to take advantage of this thing that's given?
Gotcha.
So one example is West Virginia versus Barnett, right? So
yes, although that was a free speech case,
it was a
speech
case,
but
it was
a religion case.
Right, but it still involved it involved religious people who basically objected to the having to be forced to say the Pledge of Allegiance and basically affirm something that their religion, technically doesn't allow. And they did, they did bring up that Barnett case a couple of times and things like that.
The government brought it up a couple of times too.
But there's been other cases too. There've been a lot of other cases that deal with things like evolution, teaching evolution in school. There was a more recent case a few years ago, Wood versus Arnold. It wasn't a Supreme Court case, but that was a case about high school students that were learning about Islam. Mm-hmm. And they had to, it was something to the effect of there was an assignment, you had to learn about Islam, and then you had to fill in the blanks, like what are the three tenets of Islam, and whatever. And a family objected and said, "This is, you are compelling me to believe this thing." And the courts were basically like, "No, we're not. It's like, this is just learning about religion. We are not asking you to profess a belief. We are not asking." And so in that case, it ruled in the school's favor. You can't. I don't know if that was an opt-out case. I don't think that was an opt-out case, but
no, they were trying to regulate the curriculum itself.
Regulate the curriculum. And so my point is that there have been numerous decisions, and I think the respondent that was something that he leaned heavily on is like, we've got 40 years of precedent here.
Yeah, going back to Mozart, which is a Sixth Circuit case from 1987, right? Which is almost 40 years old, which is terrible because that's the year I was born. So
that basically, I think part of the argument is like, listen, just exposing people to different viewpoints, right?
And that was a huge part of the argument, was like, how do we define that? And I think like Justice Barrett, like that was one of her first questions, is like, what is a burden? How do we define burden? Because that is going to decide this case, or at least that was the question presented to the court. And Barrett even says at one point, like, that's the question before us. That's the only question before us, whether or not this is a burden. And then like, whether you get an opt-out or what happens next, like that's not a question before the court. And so like, kind of reading the tea leaves here, like it seemed like at least a couple of the justices were prepared to try to answer that, like, what is a burden question? And then kick the rest of it down the road. I mean, to kind of see how it plays out after that.
Although there were also some justices who were taking the view that it doesn't matter whether there's a burden or not, because if there's something that they consider to be religious discrimination, then I don't have to show a burden. I just show that, and then we get to strict scrutiny. What that history of the cases shows is that, one of the arguments that the lawyer for the petitioners, for the parents, made was, don't worry that this is a really broad opt-out. Yes, it should apply to there should be a constitutionalized opt-out right for anything that you have a religious objection to, but that doesn't actually happen. People don't really complain about other things other than this.
Yeah.
But that's not what the cases show.
No,
exactly.
Yeah. You open the door, people are going to walk through it, man.
Right. Yeah. And that was an argument that they made in response to that. It's like, well, and I think it was Justice Kagan kind of said like that, even if that's true, which it's not, even if that's true, if we say that you have a right to opt out, the future is going to look very different, because now everyone is going to be doing that, which goes to another thing that came up a lot, which is feasibility. And she did, I think it was Kagan who said, what does this mean for the high school student who wants to opt out of evolution or something to that effect? And I think it was Baxter's response was, well, that kind of stuff doesn't really happen.
And I've litigated cases about education on evolution and religious objections to it. And, what schools do is, there are some schools that just don't teach evolution, and that's a real problem for American education and for the kids. But for the ones who do, the routine is normally this. If I ask a question on an exam, what is Darwin's theory of evolution, or what does the theory of evolution say about X? And the student has to be able to answer that question is, here's what the theory says. And then if a student wants to write, but that's not true because the book of Genesis says otherwise, the student doesn't get and can't be downgraded for that. But the student can be downgraded for answering the question not by first explaining what Darwin's theory of evolution is, but by instead saying that's all garbage, and therefore I'm not going to answer. I'm going to tell you what the book of Genesis says instead. Those are different things that get to exposure to ideas versus compelled belief. And that's where I think there is a very logical line.
Right. Mm-hmm. And that's the line that lower courts have drawn since Mozart, is this distinction between exposure and coercion. And, we saw everyone trying to grapple with that line drawing, right? Jamie, you mentioned kind of like we're talking about the parents' rights. There's also like the students' rights. And I think the school at one point says like, I think these are the same thing. But, defining burden here, whether it's exposure, coercion, the fact that these books exist in the first place in schools, like everyone had a different answer for that.
Yeah. And I think, what is exposure versus what is coercion was a very sort of muddy discussion.
I think it was Justice Kagan was looking for some lines.
Yeah, there were a lot of there was a lot of line searching going on, and I don't think anybody got any good definitions of where that line could be, and there were a number of times I remember, like I'm just looking at my notes from yesterday, and there's a number of times where I wrote in my notes, well, if this is how they're sort of interpreting this, then all curriculum is coercive. Like you will not be able to say, like, being exposed to something is coercive in and of itself, and that there is no line between exposure and coercion. They're the same thing.
And the Petitioners' Council and the government were very much shared and expressed that view, that you ought to be able to have the same constitutionalized opt-out right to anything. But Petitioners' argument was, again, don't worry about that because it doesn't actually come up. Or, yes, you have to let everybody out on these things. You don't have to change the curriculum.
Yeah, that was the other argument, right?
Like this isn't
this is not we're not asking for much. We're just asking to be removed.
Well,
we're not asking to change what schools are doing.
And that's disingenuous too, I think.
I think so too. I mean, it gets to the reason that they can have an opt-out in across the country in most places on sex education is it is a discrete thing in the health curriculum, whereas the possibility that will come up somehow or another. A student asks a question, a student draws a picture of my family, and my family has two moms. All the ways that things come up throughout the curriculum, and these parents want to make sure that their children are exposed to none of that under any circumstance. They get warned in advance. They get to opt out, and that just doesn't work. That gets to these deep administrability concerns. That doesn't happen when you're trying to avoid the idea that there are gay and trans people in the world, as opposed to, how to use contraception or something like that.
And Justice Jackson asked that question.
Yes, she did.
Because she gave a bunch of hypos, and I love me a good hypo, right? Like
I've got a Jackson hypothetical for you. Do you want me to play it?
Oh, yeah.
Yeah.
Okay, here we go.
I guess in following up on that, I'm just not sure I understand your answer. So is it a burden for a religious student who is being taught at home and through their religion that gender is not a situation that can be changed? People should not be in a transgender circumstance. Is it a burden for them to be in a public school classroom where the teacher is referring to another student by what this student believes is the wrong pronoun or whatever?
Well, I think the relevant burden there would be the parents' religious exercise, as we've conceived of, like the nature of the religious beliefs in this particular case. As petitioners know, you could also have questions with respect to the students' free exercise rights. I think that's a
so. Is it a burden on the parent to have their child in a classroom with a transgender student, and the teacher is referring to them by pronouns that the parent thinks is inappropriate?
I mean, I think even under respondents' view that would in fact constitute a burden on religious exercise, and here's why. It is a burden on religious exercise in the parents' view because not only do they have a religious obligation to ensure that their children are not sort of exposed to the idea that you must sort of recognize people's pronouns in that particular way, but I think even under respondents' view, there's a level of compulsion or affirmation of a particular view of how someone's pronouns should work.
Wow. Interesting. Yeah. So there's that distinction between like parental rights and children's rights, which kind of gets glossed over with a lot of this stuff. And it like got glossed over in Wisconsin versus Yoder too. That was something that they raised. One of the concurring or dissenting justices raised was like, what about students who might not want to do this stuff or might disagree with their parents? You know, all of that is put to the side. Yeah. But I think like, Richard, I think you were making this point earlier, like, the sweeping nature of the right that they're arguing for here. Like, I think that hypo gets perfectly at the heart of it. Like, just the existence of a transgender student in the classroom with the teacher using that child's pronouns would constitute a burden under some of these ways of thinking about burden. Because, you know, I think the way that they're defining burden, the petitioner and the government was like, if the parents say it contradicts their sincerely held religious beliefs, then it is a burden. Yeah. And like, you basically just accept what they say. We don't look to this idea of exposure versus coercion versus affirmative act, because that's kind of what the government was, or the school was arguing here is like, no, coercion requires you to affirm something, to take some act in affirmation of a belief or to accept a belief and express it as your own. And like the fact that she admitted that is as far as she's asking the Supreme Court to go, like, I think that goes way too broadly.
Well, I mean, I think what ends up happening there, and, you know, to sort of round out what I guess would be the parents' sort of argument here, and we can move a little bit more to the school board's arguments, but if the parents get what they want, then essentially you've got a system where anybody can opt out of anything at any time, period. Like,
as long as it is based on a sincerely held religious belief.
Right. But they talked about that. And there's, you know, like what constitutes a sincerely held religious belief. And that's a very low bar, right?
It is, right? Because the justices were talking about what that meant. And you basically, like, you just have to look. You
basically just have to say
whether or not they're lying.
Yeah.
That's the only thing you can ask.
Yeah. And in most cases, it's probably going to be hard to prove that somebody's lying about this. And so it's almost like saying, you know, if I say it's important, and end of story.
And this also gets to whether that opt-out right is really just requesting an opt-out, or in fact is requesting a change to the curriculum and the educational system. Because what do I do with saying, if I'm going to, as a teacher, call student X by her preferred pronouns or her preferred name to go with her gender identity, and that is a burden on the religious exercise of the parents of some other kids there. Do I excuse them from the class? What does that look like? Where do they go? Who's managing them? Right. What actually happens is that I shut up and I don't say anything. I try to avoid those situations, which means I don't use the instructional materials. I don't call them by their names. I don't do any of those things. And so we wash out, and we have in fact had those parents' demands for opt-outs rewriting what the curriculum and the instructional process are.
And I would go one step further and say, like, you know, let's take the pronouns things off the table. Like, you wouldn't even be able to say to a student, you know, these permission slips are going home for this field trip. Can you ask one of your moms to sign it? Right. Because you are acknowledging that this student has two moms.
But take it even further, you couldn't have Valentine's Day.
Well, and now listen, they did talk about how there are a lot of carve-outs across the country to Valentine's Day and Halloween and these kinds of events. And I will say, one of the points that the parents were trying to make here is that this is not a huge burden on schools because, you know, we're not asking them to do anything, you know, different. We're just asking them to allow us to remove our kids from these things. And it happens all the time. that's kind of how they frame it. They reference things like opting out of the sex ed curriculum. They reference things like Halloween and Valentine's Day or whatever. But things like Halloween and Valentine's Day, these are not critical components of the curriculum necessarily, not in the same way that the English language arts curriculum is. And this is one of the reasons why, the English language arts curriculum is on a completely different level than Valentine's Day celebration, or this or that, right?
Right. So, Jimmy, a lot of what you're talking about goes to like the general applicability prong of the free exercise standard.
Yeah.
Which I want to get to that in a second, because I think Gorsuch and Kavanaugh really kind of are hitting that, because to me, they kind of want to sidestep the whole burden analysis completely, and they just don't want to touch this question of burden, because I think it's just too hard. And that's actually like one thing I noticed is none of the justices, barring maybe one or two, like seemed sympathetic to the argument that just having this available to students was a burden. Like maybe Justice Alito was sensitive or sympathetic to that, but like I didn't see anyone else really pick that up. Like even Barrett was asking for lines and asking for definitions and alternatives. So like, that kind of gave me a little bit of maybe a silver lining perhaps, right? But, I think the feasibility issue is a big one, because a ton of justices raised it on both sides. Like, oh, this isn't a big deal, versus this is going to fundamentally alter what schools do and how they do it.
Yeah. And I think that was from an educator's standpoint as a former principal. I don't feel like that point was addressed sufficiently in the nearly 3 hours of arguments about what this actually means. Like there were so many implications that like, we are not asking for anything. And what kind of burden could this be on the school? You're just asking for somebody to be removed. And there were a couple of times where it was mentioned, right? Like, listen, there's a lot of if kids opt out, we've got to provide supervision. We've got to put them in take them out of the class. And hey, if we're taking them out of the class, then that's removing them from this sort of this right to education that they have. So we've got to do something else with them, which means alternative instruction, alternative supervision, blah, blah, blah. It was mentioned, but I don't think that the severity of this, the gravitas, right, of what this means on a daily sort of practical basis in schools, that was not communicated.
There was an amicus brief that talked about this. It was the School Superintendents Association that went through and in some detail explained two things. One is what actual opt-outs are allowed across the country as opposed to what might have been described, and then those sorts of practical problems and some of the ways that they then devolve to what's really about control of inevitably devolved to what's about control of the curriculum. But it didn't figure nearly as much into the oral argument as I would have liked.
Right. And Justice Jackson at the very end, because she's the most junior justice, so she kind of gets the last word. She asks the lawyer for the school district, she's like, where would we look for examples of the practical implications of opt-out policies and the feasibility of this? And I think she even says like, would it be fair to look at that amicus brief? And the lawyer says, yes, no, it absolutely would. Please look at that.
Yeah. And I think that's really important because it speaks to what folks who actually have to carry these things out, what they have to deal with and what they have to address. And when you add that to religious pluralism in this country is breathtaking in its expanse, and that is a good thing. But it also means it is a great thing. But it also means that people will have sincere religious objections to things that, as a school administrator or teacher, you just would never expect going in.
Correct. And
we don't want to privilege some things because I'm familiar with them, as opposed to the ones that I don't. That actually is religious discrimination. We have to treat these things the same way, and we have to figure out what to do with the fact that I object to something in the history curriculum and you object to something in the science curriculum, and we object to different things, and maybe we have opposite objections to the same thing. I think this has to be in the curriculum, and you think it can't be because of our religious beliefs.
And you know what? I think this is the crux of the issue. Okay. And they talked about it on a number of occasions in terms of local control and everything. The reality of the situation is opt-outs happen in schools beyond sex ed. Okay. I was talking to a teacher a few weeks ago who basically said, my principal came up to me and said that they heard from a parent that we were going to be covering this unit and they weren't comfortable with their kid doing whatever. And the principal asked me to create an alternative assignment or whatever. And the teacher was basically saying like, well, I did it because my boss told me to do it. Right. But I think what that illustrates is a level of sort of customization, a level of communication and dialogue that can only take place at the local level. And I think some of the, Justice Jackson, I think was alluding to this, and I think Kagan as well, that if we constitutionalize this, then we take all of that away. Right. And all of a sudden nuance is gone. Now, I'm not saying it should be a free for all and all of that. And I think that's one of the reasons why the amicus brief, the Superintendent's Association, if I recall correctly, they didn't take a strong stance one way or the other.
No, it was a brief in support of neither party, meaning that they're saying, we're going to explain the reality of the world here, and you figure out how that maps onto this case. We're just going to tell you what we actually have to deal with every day.
Right.
Yeah, and I think that's
great.
And I think that really captures, at least for me as an educator, like going through and looking at this case and everything, my first reaction was, listen, school board, you've got these noble aims about, making your curriculum represent the diversity that exists within your community. And therefore, you're going to include materials that represent the people in your community so that the students can see themselves within the curriculum and, blah, blah, blah. And, and I'm all about that. Right. But I think where I ended up landing on this is like, man, if we litigate ourselves to death and we essentially force a legal decision that favors one side versus the other, then we're going to lose very important communication and dialogue that exists at the local level that allows our schools to operate and be responsive to the needs of the community. And those community needs differ. And, we've got these democratic processes and parents can have a voice in creating the curriculum and voting for their school board members and things like that. And the more we pull all of this stuff out and make these high courts make these decisions, then we water down all of that, right?
Right. Yeah, we lose so much of those relationships, because if you make a rights claim, that basically means that like you have to treat me a certain way, and it basically removes a lot of stuff from dialogue and conversation. But allowing folks to like have this kind of opt-out right also undermines kind of one of the primary goals of public common schools, right? Which was
an educated citizenry.
An educated citizenry who are exposed to kind of like a shared experience based on shared values and ideas. And like opting out into a piecemeal thing, like completely undermines, if not eliminates, that motivating goal for public common schools. So, Justice Alito wants us to look at history and tradition. And that came up a little bit in the argument, but Alito was dismissive about it. And he even said, just because we've always done it doesn't mean it's been constitutional, which floored me because he's the guy who wants me to look to history and tradition to decide if there's an Establishment Clause violation. And if that means that just because you've always done it doesn't mean it's constitutional, I don't know what an Establishment Clause violation is now.
Right.
Yeah, one of the things, there are two things about that, right? One of the things is that a majority of the court, and Justice Gorsuch being really kind of the leader in this, have been pushing this idea of looking to history and tradition for, as you said, the Establishment Clause, the Second Amendment. It's come up in, a trademark case. It's come up in all sorts of things, but the one context in which they will not do that is the free exercise clause. And there's something weird about breaking apart and saying that we're going to look to history and tradition for the Establishment Clause, but not for the free exercise clause, as though they're different histories. They're not. They're the history of religion and the public schools, and the particular clause you might litigate something under. Yeah, there are real doctrinal things about that. But what actually was going on the ground isn't any different. And so to look at it in one context and not in the other is bizarre.
Right. Yeah, because the school cites a case from like the 1850s that kind of says like no parent opt-outs in loco parentis. Yeah, we're sorry. And I forget who says, but somebody's like, oh, well, that's anti-Catholic bias. Like that's neither here nor there. And I think Justice Alito even says like, why'd you cite it?
Right.
And, the answer is like, well, it's part of history and tradition, which is one of the things I'm supposed to look at. But that historical tradition really kind of undermines the parents' argument here because of the goals of public schools, which I think is why like Justice Gorsuch was so, to me, felt very like, how do I get around finding a burden here? Because he's looking for, two things. Is this like religious discrimination? So like, is this animosity towards religion? And he points to a lot of things that different folks said and kind of like, maybe they belittled religious viewpoints and things like that. Or is it not generally applicable? Meaning that like, Richard, I think you said, if there are carve outs for anything, then religion deserves the best treatment of anything, right? Or the same treatment that anything else gets. And I think that like, to me, that felt like where they're going to go, because they're going to kind of say like, this isn't generally applicable because you've got carve-outs for the sex ed curriculum and other curricular things that you allow opt-outs for lots of other reasons. Therefore, you have to allow religious opt-outs as well. And then that avoids the burden question. But I don't know. And like, I did promise that this episode would be shorter than the oral argument. So maybe this is where we kind of like do our like what's going to synthesis of what we think is going to happen.
Yeah.
Because, I think that's a good segue because like Justice Gorsuch doesn't seem like he wants to touch the burden analysis.
Right.
Kavanaugh also doesn't seem to want to touch it because he's much more focused on like the animosity side of this equation and whether or not religious folks are being treated fairly.
Yeah. And Alito seems to be of the, what's the big deal? It's just an opt-out sort of.
Right. And like, he seemed to be the one that would be most likely to accept the idea that exposure to these ideas burdens religion.
Exactly.
Whereas, I think the liberal justices would much more say like this distinction between exposure and coercion has been working for 40 years. Let's just stick with it.
Yeah.
Well, and one of the things, one of the puzzles is going to be if the court is looking for a way, and in the way, I think, Chris, you're right. What Justice Gorsuch was doing was trying to find a way to get to strict scrutiny without having to find a burden Yeah, from their perspective, I suppose that makes it easier. But what it does is it means that it gets back to where a different route to where the petitioners want to be, which is that anytime I say that my religion is that I have a religiously based offense to a particular part of the curriculum, I get strict scrutiny. Traditionally, strict scrutiny meant that the government was pretty much always going to lose. If we actually start having these fights at the level of strict scrutiny, where it becomes a serious debate who wins or loses, that kind of changes the nature of that constitutional analysis. And if we don't, then the supposed protections that petitioners described and that the government sort of described really don't amount to anything.
Mm-hmm. And yeah, because it's strict scrutiny, it has to be, the government's actions or policy have to be necessary to accomplish a compelling governmental interest. And like, there was a lot of arguments here about like, oh, well, if we get to strict scrutiny, then obviously petitioners lose based on that hypothetical. And like, to me, that's not as clear cut. But Richard, to something you said, I think there's different ways to get to strict scrutiny that mean that the right is triggered in different situations.
Yeah.
Because if they say like, okay, well, kick it back to the lower court to look at whether or not there was religious animosity. If it's based on religious animosity, that means you only have this opt-out right when there's religious animosity, right? Or if they say, look, it's not generally applicable, therefore, we get to strict scrutiny and you have to allow an opt-out right. That means that if you don't have opt-outs at all, then you're not going to trigger strict scrutiny. So like it's different ways to it's going to change how schools respond to this thing.
Totally.
Because if you say exposure is a burden, now just having it in the curriculum triggers it, and everyone's going to have an opt-out.
Well,
and I saw them
or
looking
you're going
for
to
a
have
lot more
or you're
ways
going to have
limit
the
it.
most watered down vanilla curriculum that has
Right, the least common denominator.
Yeah.
Right?
that has nothing in it, basically.
Yeah, you either you get that, or you get this weird situation where schools districts have to decide, do we allow any opt-outs? We allow it for everything, which gets to this mess that also, I think you're right, Jamie, leads to the watered-down curriculum. Or do we give nothing? And then is that going to be treated as religious discrimination or hostility toward religion?
Exactly.
And then we have the same claim coming up in different language to complain about that.
Mm-hmm.
Right. Yeah. No, it's a rock and a hard place, right? In a lot of ways. So I saw that kind of as one potential approach. And Richard, I want to get your take on this. Like, another potential approach is what I saw kind of from, I think, like Justice Barrett and Chief Justice Roberts, where like they're trying to figure out how to define coercion here. And they're like, they seem a little bit on board with this idea of exposure versus coercion, and that being the line. And like all of Justice Roberts' questions, Chief Justice Roberts' questions, which like he was pretty quiet during this argument, which I thought was a little odd.
Yeah.
But, maybe he's just kind of playing quarterback back there, calling people's names. But his primary line of questioning was about like the age of the students and how that influences how impressionable and coercive having this stuff in schools is. So like Justice Kagan asked, like, where do I draw lines? And she said, like, do we need to look at the age, the subject matter, the nature of the instruction? And I think that there's a 5-justice majority in here that could articulate a line of coercion based on those considerations.
Right.
Yeah, there sure might be. The petitioner's argument was no, it just should be absolute. But yeah, I mean, that's something that we've had courts deal with over the decades, going back to, call it the 1950s. In the area of religion law is figuring out what compulsion is, in part based on, from the perspective of the students, how they receive things. A difficulty with that was principally in Establishment Clause jurisprudence, looking at the perspective of the students, but compulsion was in the Free Exercise Clause jurisprudence. We looked at those things, and the court sort of hasn't wanted to do that in recent cases either. But there is a logic. Right. There is a logic to recognizing that the student's perspective should inform how we figure out what's likely to be coercive, and that, I guess, could suggest something about age.
Right. And in Kennedy, that opinion like kept alive some of that coercion Establishment Clause line of cases too. So like, thank you for letting me down easy with the there sure could be. That was that's such a great teacher lawyer answer, where it's like the student said something and like it's not 100% wrong, but it's also not 100% right. So there sure could be, Chris.
No, I think it could be exactly right. It's just we don't know enough yet.
Right. Well, and that's the thing, is like reading the tea leaves from oral argument is so tough.
It's hard.
So we'll have to just wait until this opinion comes out.
I think that, I think one of the things that we're going to see with this opinion, though, is like it could go in the extreme one way or the other, and that could have massive implications for schools. Or it could be a very sort of narrowly tailored kind of opinion that doesn't necessarily extremely favor one side or the other. It might favor one. My guess is it will probably favor one side a little bit more.
Or it doesn't say anything and it just says, here's the standard, we don't know how it applies, and it kicks it back.
Right.
That's kind of the way I'm leaning.
And
that could be the optimist in me.
And that's kind of what I'm hoping for, just because I feel like anything else is
going to be really disruptive.
Is going to be tough on the system.
I think that's true. Drawing a new set of lines, when we have a set of lines that school districts, school officials have understood for a long time and have actually worked pretty well. Now to say we're going to draw this completely differently, it's hard to know what will follow, although there are some things that seem really particularly dangerous to me.
Exactly.
Yeah.
Well, let's leave it there, because we are going to come back in the summer at some point once we get the opinion, and we're going to do another episode where we break down the opinion for you and actually
opinions, because there's
there's going to be a lot.
There's only going to be
That's right.
one.
Yes, exactly.
That's right.
Actually, over under 4 opinions.
4, you think so?
I'm going to take the over. I think at least 5 justices are going to write opinions.
I think that's quite possible.
Yeah.
I would be just 3 doesn't seem like enough.
No,
Right? That's why I picked 4.
Yeah,
that's
right.
good. Good number.
I think at least 2 different dissents with slightly different perspectives, a majority opinion, and probably 2 concurrences. Maybe more.
There's going to be an Alito concurrence. There's going to be a Thomas concurrence. I think the Chief Justice writes it.
This is a big one.
Yeah.
It's a big one. Well, Richard, thank you so much for joining us and providing
thank you for
that.
having me.
Oh, we love it. You
Great
can come
fun.
on anytime. Chris, what's our homework? We burden you to listen. It shouldn't be a burden to listen to Chalk and Gavel.
It sure might be to coerce your friends and family to listen to Chalk and Gavel. Find us wherever you get your podcasts. Like, rate, review, subscribe. You can go to our website, chalkandgavel.com. We've got our teaching guide up there along with feedback survey. We'd love to hear your thoughts. You can find us on social media or on Patreon at patreon.com/chalkandgavel. Your support means the world to us. Richard, this was so much fun. Thank you so much for being on.
It was fun. My pleasure.
All right,
Absolutely.
everybody. Thanks
and I'll
so
look forward
much.
to what you guys have to say after the decisions.
Thank you.
Me too.
We'll see you again in a couple of weeks.